Well, welcome everybody. Here we are at the top of our start time. Welcome. I'm Francisco Sirvent. Welcome to this webinar, 6 Celebrity Inheritance Nightmares. We get to poke fun at the celebrities and the nightmares they left behind. My name is Francisco Sirvent. If we don't know each other, welcome. Thank you for joining. I am happy to show you this because as an attorney who does estate planning and probates, and we deal in this world with all of our clients, it just highlights, and honestly, celebrities are just so easy to poke fun at that we don't get to make, we don't have to make fun of us normal people. We can make fun of celebrities. So that's what we're going to do today. I've got 6 specific examples that I think just show some really funny stories. But I think the other thing that this shows is if you're one of these people who have sort of been suspicious about lawyers and wondering, what do I need to do to, do I need to do something for my family? Well, yeah, but you're going to, I hope, realize that not only were some of these stories that we're going to talk about, are they just not good examples of lawyers. They're examples of lawyers doing bad jobs for people, because if you've been suspicious about, is the industry really out to get you, I won't dispel that myth today. I won't. I think what you're going to find is that, there are some really bad lawyers out there. And there's some really just unscrupulous people who want to crawl out of the woodwork and cause trouble. And you know what? When that happens, it becomes a mess even for us normal people. So that's what we're going to dig into. Now, I know some people who are watching this are already clients of ours. Welcome. I hope this is good information for you. I hope it gives you some reminders of some concepts you already know. But for those of you who aren't clients of ours, maybe this is your first experience with me, I'm very glad you're here. I know you will learn something new because, some of this stuff, every time I prepare for one of these web classes, I'll learn something new myself, and I've been doing this for almost 14 years. So stick through. We're going to cover a lot of stuff and cover a bunch of things. If you haven't met me, I hope we get to meet sometime in the future, or at least you get to meet with someone on my team. Any chance I get to brag about my wife and my kids, I will. And that's who that is, my wife, Nicole, my 4 kids, Gabriel, Bella, Sophie, and Zach. I'm the founder of Keystone Law Firm. All we do is estate planning. We protect people's assets so that their family doesn't have to fight about it, either among themselves or with the probate court, right? So it's just become simple and easy for your family to take care of this business. I'm also a 2-time author, and that's exciting and fun for me. I love sharing this information and experience that I've had. But the state bar is very strict about this. I got to go through this quick disclaimer. We do lots of education like this. You can jump on our YouTube channel, on our website. We've got tons of information there. So feel free to do that. But this information that we're going to talk about today is not specific legal advice for your situation. I'm going to talk about a lot of things that I would have done to fix the problems that these celebrities created, but don't take it as specific advice for your situation, okay? It is general information of an educational nature, which means I hope you learn something from it, but if you want specific advice for your family, make sure you sit down and talk with someone. Our team would be happy to do that if you need to. All right, let's just dig right in, right? Okay, what problems can happen? Now, as I was getting this ready, I almost hesitated to even do this, because this topic can, celebrity disasters, while it's fun and entertaining, we can immediately, at least I know I can, and I'm sure other people, do this, we can immediately say that there is nothing in the world that is like my family and all those celebrities who are flying around in their private jets and on their private yachts and blah, 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 right? We have nothing in common. Their problems are not my problems. Their situation I will never have to deal with. My family will never have these problems. But while I acknowledge that, I absolutely acknowledge that us normal people, we won't have the whole package of the problems that they have, right? That they experience. But what we get to do is we get to use them as our case study, I guess. We get to use them as the examples of how problems happen. So many of the horror stories or the disasters or the nightmares that come up for families and children and loved ones come up and happen on a very private, I'm going to say private scale within our public court system. But all the details, they don't make it into the media, they don't make it into the news stories, they don't, it doesn't get pushed out there as much as the celebrities do. And so why I actually really like the concept of using celebrities to illustrate the disasters is because the details are so well published. And we know all there is to know, I think, about most of these stories. And so it becomes a really useful tool. And if we look at it from that perspective, then we won't miss the lessons that we can learn from them. And we can still understand how those lessons can be translated into our own family's reality. Because, yes, my kids will never have to fight over a $50 million yacht. I don't expect that they will. They maybe will win the lottery one day, right? But the lessons that come out of that, I can absolutely translate that to my kids and how I don't want them to be torn apart or torn to shreds by fighting over something that I didn't take care of. So that's how we're going to translate this. I don't want us to miss the lessons that we can learn here just because we say they're celebrities and I'll never have these problems. All right, so let's dig in. We've got 6 celebrity inheritance nightmares. We're going to use Anna Nicole Smith. We're going to use Prince. We're going to use Whitney Houston's story, Heath Ledger's story, Michael Jackson, and one of my admittedly favorite bands from high school. They weren't contemporaries, but I really appreciated their music, was The Doors. So Jim Morrison's death. So we're going to go into each one of these. Each one of these celebrities gives us a specific example to dig in on. So first one, let's just dig right in, is verbal promises. Verbal promises. Now, we deal with this. We actually do deal with this a lot in our probate practice, where somebody has died and they come to us and they say, so-and-so said A, B, C, or X, Y, Z, and that's what they said, and that's what they said over and over and over. That's what they wanted. Well, that's what happened with Anna Nicole Smith. So if you know the story, I mean, it just maybe, I'm sure, hopefully it was true love. She married J. Howard Marshall II. He died at 90 years old, but it was only a little more than a year before that they got married when he was 88 or 89, and Anna Nicole Smith was 27. Okay, awesome. I hope it was true love. I hope it was for real. I guess we'll never know. He passed away at 90. Now, at 90, his estate, here's, an interesting tidbit, was worth $1.5 billion, and he left the whole thing. He actually did leave it into a trust. So he did some estate planning. Good. Well, what Anna Nicole Smith didn't like is that she claims he told her that she was going to receive a big portion of the estate. But guess what the trust said? The trust said she got nothing. Nada. Literally zero. And so, well, he dies, sure, maybe her intentions were all pure while they were alive, and And he really did promise her that verbally. So after he passed away and they had to file some paperwork, the trustee had to file some paperwork in court to get some of the estate administered, and she ran in there, filed her objection, and there it went. So she came in and she said, he promised to give me, and the specific promise she alleged was half of his income that was earned during their marriage. So I don't know what that amounted to. I'm sure somebody who has an estate of $1.5 billion, it probably would have been a significant chunk of money. And actually, it was interesting. His son, Marshall III, who was also left nothing, he also filed an objection and said that his father had agreed to leave him the same amount in an inheritance. And so then, bam, now there's $1.6 billion going through this estate. And it essentially turned into years and years and years of litigation. It went through the trial court to the Court of Appeals, actually went to the Supreme Court. There was litigation in Texas. There was litigation in California. There was court cases brought both at the state level and the bankruptcy court federal level. This thing went back and forth, crisscross, over and around through different courts, different attorneys, different states, and it just seemed to drag on and on and on. And they were essentially alleging and fighting that he was, his will was invalid, that he, was incapacitated or something like that. And Anna Nicole Smith actually got one court in California. I couldn't believe this. $450 million. $450 million. Unbelievable. I'm going to reboot the video here. It looks like we had a little internet glitch. Hopefully my audio is still coming through. But the California court actually awarded her $450 million. It was reduced to $88 million through some other rulings and things, which, good lawyering can kind of maneuver all of that stuff. But then it just kind of kept going through court, kept going back to court, kept going back to court. And actually, in the end, she died. She died before there was a final ruling. But she received nothing. She literally received nothing. She argued and argued and argued. And then her estate argued on behalf of the whole of her claim, kept arguing it, and she got nothing. Her estate got nothing. There you go. I guess this is one of those examples of his estate plan being honored. I mean, truly, his estate plan said he didn't want to leave her anything. And it was eventually, after lots of battling, it was eventually upheld, which is amazing, right? Through all of and you can imagine, she would have hired the best lawyers. She would have hired, the top dogs in the industry. And it ended with her losing. Now, on the flip side, I'm not going to judge the situation, I guess. If he truly did really want and told her, I want you to have something out of my estate, out of my trust. And he told his lawyers to get it drafted, and he told his lawyers to make it happen. If he truly did all of that and it didn't, and he relied on that, then that's a big, giant mistake. That's a very big mess up. I mean, can you imagine if that was truly what was supposed to happen? The devastating consequences that resulted in for her. I mean, I don't know how much she spent on attorney fees. I can only imagine it was in the millions of dollars. And to then end up with nothing, if you look at it from that perspective, then it's a big, giant loss. So this is the first example of how verbal statements cannot be honored. They cannot be followed. You can't rely on them. It doesn't matter what the verbal statement covers, whether it's the jewelry, the personal items, the car, the house, bank accounts, investments. It doesn't matter. Verbal statements will lose every single day of the week and all year long and forevermore. Let me just double check my internet here. All right, so let me just see if I can reboot that. Okay. Sorry about that, guys. My, with everybody working from home and everybody getting ready to start school online, internet is a precious commodity these days. So, all right, I'm not sure if that's going to reboot, but I can keep going here. We can at least do this verbally. So what should have happened? Oral promises cannot be enforced, and never ever ever rely on an oral promise. If you have something that you want your family to know, if you want them to have, then please get it in writing. Make sure you get it in writing. There's lots of easy ways to get that in writing, and that's the way that it's going to protect them from having to second guess what you really wanted. All right, let me pause. Desktop app. Okay, let me. Looks like it's rebooting here. Hang on just a minute, everybody. Okay, I think we're coming back live. Hopefully we are. I'm going to bring my screen back up for you. All right, so let's go to our next celebrity disaster. This one is brought to us by the artist formerly known as Prince, and he passed away just in 2016. My wife absolutely loves Prince. I honestly, his music just doesn't move me. And so I don't, take it or leave it, I guess. He passed away in 2016. Massive, massive collection of music and royalties. And I think his estate was estimated at around $300 million. And, with artists who, especially music artists, their music is going to continue to earn royalties and it can be for a long, long, long time after their death. And so their estate has to deal with that in some way, say who gets that income, that future income that's going to be earned. So he died at the age of 57, and he literally didn't have anything. Nobody found any will in place at all. They found nothing. And so his family was left with, I guess we go through the laws of intestacy, right? Somebody who doesn't have a will, there's a whole set of default laws and rules that say who gets what. And his estate is under Minnesota law, but it's the same way that it would have worked here in Arizona. He has 6 siblings who are going to, they should be receiving it in equal shares. And that's equal shares, it's how you're going to divide this. There's all kinds of complexities about how to get that done. But he literally left no will whatsoever. Now, we look at his estate of $300 million and say, oh boy, he, of course he has a big giant mess. He's got $300 million. Of course he has to go to, his estate has to go to court. He's got $300 million. Well, here's what's crazy. Our probate system in Arizona, and most states are like this, the minimum amount that takes you into probate isn't set for celebrities only. It is set for just the normal people. It's the minimum amount is $75,000. If you have more than that, then hello, probate. Welcome to probate. And the nightmare will ensue. Now, what's interesting about, one of the interesting things about Prince's estate is that all these other people have been climbing out of the woodwork and claiming to, have a share or a claim against his estate, of course, right? Well, one of them is somebody's claiming to be his son. As far as everybody knew, he didn't have any children, and this guy is a federal inmate in prison and claiming to be his son. And so they're having to go through and figure out, how do we prove or disprove this? With DNA, it's obviously not that hard, but whether or not they're going to allow some random person to just make that claim and then force a DNA test is something, I don't know if a court should do that without more evidence, right? I mean, that would mean anybody could walk in and force a DNA test. So we'll see what ends up transpiring with that. But the normal intestate laws, they say your estate goes to your children if you have any. I'm sorry, first it goes to your spouse if you have any. But if you have children from a prior relationship, then half of your estate goes to, half of your separate property goes to your blah. It's super confusing. Essentially, if you have children from a prior relationship, your children from that prior relationship will end up with more than your surviving spouse. That's how it ends up working out. Your children from the prior relationship end up getting more than your surviving spouse. So Arizona intestate law for blended families is super goofy. If you don't have a blended family, then it's spouse first. If your spouse didn't survive, it's children equally next. If you don't have children, then it's your parents in equal shares next. And so that's the intestate statute that says how default distributions would happen. But then the court has to evaluate, and it has to go through probate. The court has to evaluate how the future income is going to be distributed. And so essentially the court is going to be involved forever, or until all of his copyrights expire and his music no longer is making money. It's a giant, it's going to be years and years and decades of the court overseeing all these distributions. So that's the not having a will problem. Whitney Houston gave us a little bit of a different example. So she died unexpectedly. When was it? I don't have that in front of me. She died in 2015. And her daughter was born in 1993. Okay. So 2012 is when Whitney Houston died. So her daughter was born in 1993. A month before her daughter was born, Whitney Houston signed her will. She I'm having a child. I need to get my affairs in order. She got a will done. Good for her. She should have done a trust. She was worth about $20 million. So yeah, a trust is a no-brainer. But her daughter was born a month later. And then guess what happened? She never went back and made any updates to her will. So think about it. 1993, her daughter was born. Whitney Houston died in 2012. Well, how old was she? She was 18, 19. She was an adult. Her daughter was an adult. So the problem with not making changes is illustrated right here. In 2012, her daughter was 18 years old and was allowed in that will created before she was born, was allowed to get 10% on her 21st birthday. On her 21st birthday. Whoa. I just did a radio show episode where the title was, "What would you have done with $100,000 on your 18th birthday?" Well, I guess here's the question is, this question is a little different, but we see what happened. What would you do with $2 million on your 21st birthday? Because that's what her daughter, Bobby Christina Brown, got on her 21st birthday. And if you know the story, you know that her daughter actually died from drug overdose intoxication, and they believe she drowned in her own bathtub, I think, and she died just in 2015. It's a critically sad illustration of how an inheritance that most people want to be a blessing to their loved ones can let them destroy their lives. And it's just like everything in life. So anybody, whether it's an inheritance, it's a lottery winning, it's a somebody who had a business go berserk, multi-million, billion, and then cashed out, more money is going to exaggerate the qualities and personality traits that you already have developed. And her daughter, I'm sure before she inherited that money, she struggled with drug addiction and alcohol. And so plopping $2 million in cash in her lap on her 21st birthday only exacerbated that and ended with her dying just a few years later. I mean, intensely sad. These things can't be done. They can't be one and done. They have to be kept up to date. We preach this. I preach this all the time. It is not that hard to create your estate plan. And that's why we've made it as simple as possible to create a really good estate plan. But you can't just create it because you don't need it today. You don't need it to work today. You need it to work some unknown day, years and years into the future. And so you better have a process to keep it up to date and to check up and to make sure it's relevant, to make sure it's still fresh and recent and accomplishing what you want to accomplish. So this is just one of those really sad examples that we wouldn't want to have this lesson, but we do. So let's please learn from it. Our next example is kind of a surprise, honestly, when Heath Ledger died. So he died in 2008, and he had one of those old wills, and it said he created it before he had any kids. I think he was estimated to be worth about $20 million. He left in his will, he said to his parents and his sisters, right? I mean, you don't have kids. Maybe that's a pretty typical distribution. My brothers and sisters, my parents, whatever. Well, then you have kids. Hello, time to update things. It's a significant life change. And so he passes away unexpectedly. And boom, he's got a daughter. What's going to happen to her? Right? This is crazy. People don't know if he did it intentionally. People have, more verbal statements saying, he meant to leave everything to her, or verbal statements that, he whatever. I mean, everybody's got a different argument around where that money was supposed to go, but his will didn't match the current circumstances. If he would have written a will that said, I know I have a daughter, but I don't want her to get anything, and I leave it to my parents and my sisters, then we'd all know very clearly. But when life changes and that change isn't reflected as part of your documents, if it's just ignored, then that puts them under scrutiny, that calls them into question. And that's the problem with not having them updated. Now, thank God for his daughter. The family all agreed. They got together and they all actually agreed among themselves that this money is for her. And so they're setting it up so that it will support her and it'll be ready for her and it will take care of her and it will become her inheritance. And it's just an amazing gesture on their part because they're not legally obligated to do that. But it goes to show that there's not enough people out there saying these things have to be kept up to date. We need more of the public to know we've got to keep these up to date. Excuse me. So here we go. The next example is Michael Jackson. Oh my goodness, Michael Jackson. He's a cautionary tale, I guess, on so many levels, but also an amazing success story, I guess. His death in 2009, it turned into a estate probate litigation still going on now, and I think they've estimated his estate is worth $600-700 million. That it's just hard to really value it because of the ongoing future royalties that are still earning tons of money. But I think what came out just right after the fact was that he had a trust, but he didn't fund it. He created the estate plan, but, his fault, his lawyer's fault, whoever, they didn't put the assets into the trust. And that's, that's just it's like, I'm going to sell you a car, but you have no engine. Fantastic. You've got a car, but you've got no engine. What do I need to build the engine? Yeah, you can do it. Good luck. Go build yourself an engine. And it just is that is something that I see affect every single client that we deal with, is creating a trust and then not funding it, because we get so many people who come to us who have an old trust that they need updated, and it's not funded. They're coming to us because they created a trust a long time ago. They know it. They need to update it, and they never funded it. Oh my gosh. So it has to be funded, or we get the phone calls where somebody passed away, just like Michael Jackson's story, and their mom or dad had a trust, but, the house wasn't in the trust. The bank accounts weren't in the trust. And, we end up wasting a ton of time and money going through probate. So what's ended up happening with Michael Jackson's estate is now the beneficiaries, they've been in probate court, and it could have been handled privately through his trust forever. But instead, now the probate court is overseeing, and we don't know if it'll ever get out of court entirely. It could just be there until forever. Which is, for anybody of any family size, of any family wealth, it's just a shame to have to waste it and go through that court process. So get your trusts funded. Now, Jim Morrison, right, lead singer of The Doors, died young, age 27. I didn't know this, but when I was reading up on this example, he actually didn't have much money when he died. He had, I guess, burned through most of what he earned while he was alive. But like what happens with a lot of artists, his death spurred a renewed interest in their music, and then, generated, like almost a cult-like following for Jim Morrison himself. And so that has turned his estate into quite valuable. And when he died, he wasn't married, he didn't have any kids, but he had created a very simple 2-page will, which good, at least he had something, right? So he had a very simple 2-page will. And in there he says, I leave everything to my girlfriend, and, she survives me. If she doesn't, then I give everything to my brother and my sister. And so that's what his simple 2-page will said. So he died at 27. And what that means is, there wasn't much there at that point, but there were future royalties. Again, there was money that was going to be coming in down the road. And his girlfriend knew this, so started to claim the estate. But then she died just a few years later. But she didn't have a will. Okay, so what happens when you don't have a will? Remember, you are intestate. So she didn't have a will. She didn't have kids. She wasn't married. So her estate, which now included Jim Morrison's estate, her estate went up to her parents. Oh my gosh, right? So here this guy dies, and he says, everything goes to my girlfriend, and everything stays with her for just a short time, but then ends up with her in her parents' hands. Huh, well, that's kind of weird. Well, that's how it works. So where this led to was his parents then went in and filed a contest against his estate years later and tried to claw it back from her parents so that they could, recover it basically for his brother and sister, how he had said, if she doesn't survive me, I leave my brother and sister. Well, it doesn't quite work that way. When you use words like to my girlfriend, but if she doesn't survive me, then to my brother and sister, it doesn't go to the girlfriend, and then when the girlfriend dies, go over to the brother and sister. That's not how it works. Your will says, if she doesn't survive me. So since she did survive, that's period. That's the end of the story. It's now her asset, 100%, no strings attached, no further instructions, period. It's gone. And so that's how his will was written. And which maybe I'm assuming, but I believe maybe it was a mistake. Maybe he really would have wanted it to go back to his brother and sister. Whether or not he wanted her to be able to say, it's going to her parents or what, who knows. But if he did want it to go to her, and then when she dies, it goes back to his brother and sister, he could have said it differently. He could have said it that way. But instead, he didn't. It went to her parents. So his parents filed a probate suit against the will, claiming it was invalid, claiming he was incompetent. And what ended up happening, I think, like so many lawsuits, they end up in settlement. And his parents ended up settling with her parents. And I think they ended up splitting the estate 50-50. So now it'll go basically down through their through, maybe to their kids, however they leave it. So it got split 50-50 to the girlfriend's parents and 50% to Jim Morrison's parents. Now, the value of his estate, again, hard to value just because it's got royalties and ongoing earnings, but they know, in the tens of millions of dollars, something to that effect, is going to be passed down through the generations. What he should have done, if that's what he wanted, he should have said, I leave it to my girlfriend in trust for her life, and she can spend it, she can use it, she blah, blah, she can have a life. But then on her death, I leave whatever is left to my brother and sister equally. And we do that through something we call a protected trust, either for spouse or for beneficiaries, or you can do it for a girlfriend, like he did, or like he should have. And then it would have gone according to that instruction, right? It would have at least taken into consideration that, hey, I'm kind of a celebrity. I helped start the Doors. This thing has gotten really big and it's going to earn money for a long, long, long time. Maybe I should think, ahead a little bit about what might happen after my life, after my girlfriend's life, down the road, and just provided for those contingencies. And that would have saved that litigation. It would have saved all kinds of legal fees and problems for both of those families. So that's the last example I have. Now I know, if you're watching this and you're like me, we're not celebrities. Well, maybe you are. We have a few clients that are in that realm, and I'd welcome you to investigate us. If you're sitting here, you're wondering, what, we got to get our stuff in order because I don't want some of those disasters to happen to our family. Keep watching. I'm going to explain a little bit about how our process works with our firm. We definitely don't take the typical approach of what I see a lot of firms do, simply because I was trained in that, and I experienced how much that turned into families ending up in probate anyway, because my industry, there's not a big incentive for us to follow up with our clients over the decades to make sure their plans work at some unknown day in the future. What the incentive is to do a whole bunch of these for, $300, $600, and just crank them out, by the thousands. And what's typically what's tucked in there somewhere is a little paragraph that says, the drafter has no liability if this thing doesn't work when you die. And then what does your family do when there's a problem? They call that firm because they don't know, and they say, oh, this isn't working. It was done 10 years ago, and we have to go through probate. And they go, yay! Not really. They don't say that out loud. But then they help the family go through probate. And in Arizona, typical probate fees are going to be $20,000, around that range for a pretty normal family. If it's a probate that happens while you're alive, which I've got some other web classes on what that means. But those probates can be anywhere from $50,000 to, even $200,000 while you're alive in fees and costs and things just to manage, and act as power of attorney, act as, someone who's making your healthcare decisions. So making this work takes a lot more work from our end, but it gets you the result that really I think most of us want for our family. So let me just show you a little bit about how we work. And if you need to do this, if you want to investigate us as an opportunity for you, then I will be glad to show you what happens. So these are our packages. They start at $1,600. They go up to if you were to add every bell and whistle and everything under the sun, they can get up to $15,000. And then we have some plans that are even more than that for those who have businesses and have a lot going on where they really need to protect their assets. And they've accumulated some good wealth. And so each of those, we go through those with you one-on-one. My team will help you figure out which package makes sense, which options make sense, and in order just to help you make a great decision. And I'll explain how we do that next. But our long-time relationship with our clients, we call that our TrustCare program, and we don't take everybody into that. We just don't. It's a very specific set. We really protect our clients from us having to be dragged into dealing with the crazy people out there. There are some people that are just absolutely nuts. Our first rule is that we do not work with grumpy people. We just are not, myself, all my team, everybody on staff, we're just not grumpy people. We're happy-go-lucky. We're optimistic. We're, the future is bright, and that's who we want to work with. There are some absolute firms that have the opposite culture where they love to just be grumpy cats, and they will show up with a scowl on their face at every appointment. And for some people, that's what they're looking for. It's just not who we are as a value. I also say that anybody who owns some real estate, even if it's just one home, or has really anywhere from like $100,000 and up in the bank or in investments, absolutely should look into this, because it's going to protect that. It's going to protect that money. It's going to keep it, for you, for your family. That way you don't become a burden to your family. You don't end up bleeding the estate out, in your last couple of years of life while you're most vulnerable. And it just makes it easy and simple for them. This is a good type of person that fits us well, and we take care of them really well. But how does it work? So typically the first step is this. It's some type of education where you're just learning, and getting to know me a little bit, my style, getting to know the types of things we do, and then the next step is a one-on-one appointment. Now, right now, we're doing almost all of those one-on-one appointments virtually, either through the computer, a video call, or over the phone. And that first appointment is where you decide, yes or no, I want to work with you guys. And then third is where you actually start to build up a plan and take the steps that are necessary. We don't charge by the hour. Our firm is completely flat fee on all these services. That way you don't have to worry about being nickeled and dimed. You just know what it is going in, and you can set your budget. It's at the first appointment. That's called a discovery hour. at that first appointment where you can figure out what your budget is, or you know what your budget is, but you can figure out what fits within your budget. And that's where you're going to do those three things. You're going to help us learn your issues, help us learn your goals, and you will figure out what options are relevant just for you. So it's not a, we're not going to ask you to go read a, encyclopedia of legal knowledge so that you can figure out what's right for you. We'll whittle it down and say, these are the three things that are relevant for your situation, and make sure you understand what those are. It is a private appointment, and my team does that. We do that with our client relationship manager, and she takes really good care of you in that first appointment. There's really no pressure. It's just a comfortable, easy atmosphere. Obviously, if we're doing this virtually, then you'll be at home and you'll be in a really comfortable environment. And she'll just help answer any questions, help figure out these three things. That way we get you so you know what things are relevant for you. Our commitment, my commitment to you during just that first appointment is that you'll walk out with these 5 things. Okay, the discovery hour has a huge value because you're going to walk out learning and knowing and getting super good, high clarity on what your family's options are. Second is a personal information book organizer. This is how to organize your affairs in just a quick, short, simple tool that we've been building up, and tweaking and refining over the last 14 years, I think. The myths of financial security. There's just too many people out there who are being taken advantage of by stockbrokers and annuity salespeople, and people who just don't have their best interest at heart. There's just so many people that are paying way too much in commissions and fees, and just not, their retirement is just not secure. So anyway, the myths of financial security, dispel all of that, put you on a good track. Fourth is our Successor Trustee Handbook. This is a tool that you can use to give your trustee, the person who you've named to be in charge of things, that they can use to know what their job is. It's really critical for them to know what they're supposed to do when the time comes. That way they don't, do something illegal. They don't get a big unexpected bill. They don't end up, with a lien against their own family's house, just all kinds of problems that they need to know how to avoid. And then my book, my first book, Pack Your Parachute, we'd like to give everybody a copy of that, because that talks about a whole bunch of other things. There's 12 other topics that I cover in there to just help you just learn as much as you want about this stuff. I don't want you to feel like you can't get the knowledge you want to become as educated as possible. Total value over $1,400 just for that first appointment. I do give a 100% money back guarantee. The cost of that appointment is $125. Like I said, we're exclusively flat fee on these services, so you're not being charged by the minute. And we do that to protect your time, to make sure that my team is 100% prepared and committed for you, to give you the most value possible. And if for any reason, I do give that 100% satisfaction guarantee on this, because heck, I want my staff to do really, really good things for you. And so if for any reason it does not feel like you got the value out of that appointment, you're free to let them know. They have authority. They can immediately give you a refund. But they know that, that's not the goal, that they really want to take care of you and deliver what is promised. My team has beat me up over this summer, and I'm still offering the $75 price for the discovery hour. So if you'd like to take advantage of that, just jump online and we will honor that. We have a special link for you. It's on the screen. It's www.bit.ly/Keystone appointment. And right on there, you can just go right through. It's got our calendar. You can find a time that works for you, schedule, take care of the payment, and you show up. We've got, there's not a lot of homework for you to prepare for that first appointment. It's pretty much, we'll send you some emails, because we do want you to be able to, that's going to cover a lot of the basics. So just some, frequent questions, so you don't have to ask those during the appointment. to help you get prepared just from that perspective. But you don't need to organize your life. You don't need to gather all the information. You don't need to make all your decisions before you have that first appointment. The first appointment is just, you're just information gathering. You're just going to come, you're going to ask a bunch of questions. And if you feel like, oh, okay, yeah, this place, they know what they're doing. I feel comfortable with them. They've got a unique thing I can't get anywhere else, then great. And you want to get started, you get started. And my staff will be happy to help you figure that out. That's all I had for today. If you are already a client of Keystone and you stuck all the way through the end and you need an appointment to make some updates or changes, don't go through that. Don't go through that link. That's for people who aren't yet clients of us. What you'll do is you'll call the office and speak with our scheduler, and she'll get you scheduled for your appointment. We just have a little bit more, you get to skip through a couple things since you've already got a relationship with us. So we'll make sure you get taken care of as well. But that's all I have. Everybody have a great day. Stay safe out there in this pandemic world right now. I know things feel like they're up in the air and we're changing and things are changing every day. But if there's one thing we know, it's that life is going to throw changes at us. And all we can do is make the best decision with the information we have today. And that's what we got to do with every aspect of our life, including this stuff, our estate planning. Make the best decisions we can with what we know today, all right? So stay safe, guys, and take care. Have a great day.